Hello. Hello, everyone. Hello. Welcome to today's seminar. I'd like to start by acknowledging the traditional owners and custodianship of the lands on which we meet today, wherever that is in the areas that we all are, and pay our respects to their ancestors and their descendants. Today we're going to have a presentation of about 30 minutes from Brad Sherman, and then that will be followed by an extended question and answer session. I'd ask you to put your questions or enter your questions in the Q&A area at the bottom of the screen, we'll progress through providing answers to those at the end of the talk. Any of you that work with biological material or do research that's related to biology in Queensland will need to, I think, to understand the Queensland Biodiscovery Act, and that act has just recently been updated. So this presentation today is particularly timely, I think. Today's speaker is Professor Brad Sherman. Professor Sherman is the ARC Laureate Fellow at the Law School at the University of Queensland, and his fellowship is associated with looking at the impact of intellectual property on food security. His previous academic positions included working at Griffith University, the London School of Economics, Cambridge University, and he has really quite broad expertise that encompasses many of the aspects of the issues that are relevant to those working with biological materials. So I'd welcome Brad to talk to us about the impact of changes to the Queensland Biodiscovery Law on scientific research. Brad.
Thank you, Robert. I'd just like to reiterate Robert's acknowledgement of country and pay our respect for ancestors and their descendants, past, present and future. Today's discussion, I'm looking at, as Robert said, the impact of changes on the Queensland Biodiscovery laws. I'll begin by providing a brief overview of the context of the laws, and then focus on the changes which were introduced about 2 or 3 weeks ago. Before I do, I'd just like to pay some acknowledgements and thank you to the Australian Research Council for the laureate that's funded my research, and for people I've been working with very closely on this: Kamalesh Edgahere, Carol Ballard, Robert Henry and David Jefferson, all who've contributed in some way or other to the research. So the first thing I'll look at are the background to the key aspects of the Queensland Biodiscovery Act and the 2020 amendments to the Queensland Biodiscovery Law. The focus of my presentation today is looking at the impact of this law upon research and science practices. There are a host of other changes introduced, as we'll see, in relation to traditional knowledge. And for those people outside of the research environment, people in the industry, it's also very important that they will be subject to future events that we'll be holding. Today's focus is going to be primarily focusing on the impact the amendments have on for science and researchers working with native biological resources. There are 3 key changes in the 2020 amendments to the 2004 Queensland Biodiscovery Law. The first one is an administrative change. It's no longer necessary to provide a biodiscovery plan, as had been the case until recently. Secondly, and this is something we'll talk about in a bit more detail, for the first time in Queensland, plant materials that are included in Annex 1 of the Plant Treaty are not covered by the access and benefit sharing requirements. And the third change, which is yet to be implemented but may come in the future, is the inclusion of traditional knowledge obligations. And I'll talk about all those as we go through the talk. Just briefly, by way of legal background, 1993, the United Nations Convention on Biological Diversity made a fundamental shift in the way that plant genetic resources were regulated. Prior to this, people worked with native or biological resources on the basis that are common heritage of humankind. As a consequence of agitation, particularly from countries that had been historical providers of material, the CBD, as it's known, the Convention on Biological Diversity, introduced the idea that nation states could be sovereign over their materials. In Australia, this meant that national, Commonwealth and state governments could introduce laws that gave them some sort of quasi-property rights over biological materials. Queensland became one of the first locations in the world to do so in 2004 when it introduced the Queensland Biodiscovery Act. At the same time, the International Treaty on Plant and Genetic Resources of Food and Agriculture, the Plant Treaty, was introduced. This attempts to provide access to and ongoing use of key genetic resources for food and agriculture. In 2014, because of problems with the interpretation of the Convention on Biological Diversity, the parties got together and adopted what's known as the Nagoya Protocol on access and benefit sharing. This document ostensibly provides an interpretation of the scope of the CBD, but arguably also extends it in quite considerable ways. In 2020, the Queensland Government amended the Queensland Biodiversity Act for a number of reasons, two of which were firstly to implement the Nagoya Protocol or part thereof, and secondly to implement its long-standing commitment to respect and protect traditional knowledge in relation to access and benefit sharing. The new Queensland law, which is the focus of the remainder of the discussion, deals with effectively two types of subject matter. Firstly, native biological material, and secondly, traditional knowledge. And I'll deal with each of those in turn. So the first one is native biological material. In essence, the law provides, and I must stress, in some ways the law now is relatively simple and straightforward. The Queensland law provides that a person who obtains native biological material from state land or Queensland waters for biodiscovery must obtain a collection authority from the government and a benefit share agreement between the government and the person engaging in biodiscovery. In essence, there are three parts to this. Firstly, the obligations only arise when someone's obtaining native biological material. Secondly, it must be from state land or Queensland waters. And thirdly, it's for the purpose of biodiscovery. So I'll look at each of those in turn. Native biological materials defined very broadly to mean native biological resources or substances sourced whether naturally or artificially from a native biological resource. So this will include digital sequence information, in theory at least, and then soil containing a native biological resource. Native biological resource in turn is defined to mean a non-human living organism or virus indigenous to Australia and sourced from state land or Queensland borders, or a living or non-living sample of the organism or virus. Very broad. There is not really much that's at stake or issue in relation to this. The one area which it's not really, we'll go into much detail, is the status of digital sequence information. The question has arisen in relation to the CBD and, according to Queensland laws, whether the definition of subject matter here, native biological material, whether it includes sequence information. So someone sequences a Queensland source macadamia, is that covered by the laws? An issue which is, I think Robert and I will discuss in more detail in the future, arises because material is defined as a substance which is sourced whether naturally or artificially from a native biological resource. So the artificially would probably include it, particularly given that sourced means in the second part, information or is synthesized from that material. The key question here is whether it would include a substance, and it's something that we'll come back to at the end of the presentation. Secondly, the Queensland law only applies to the Queensland law in relation to native biological material only applies to material that's collected from Queensland state land or waters. It does not apply to private land or Indigenous land. And this is a very important feature to be kept in mind. And it's one of the one of the shortfall into the Act, I think, in going forward. So the law only applies to state land or Queensland waters and the collection of plants from their own. Thirdly, the law only applies when someone's engaged in biodiscovery. Biodiscovery is defined in the Act to mean biodiscovery research or the commercialisation of native biological material or a product of biodiscovery research. In turn, biodiscovery research is defined as the analysis of molecular, biochemical or genetic information about native biological material for the purposes of commercialising the material. So there's two things here. Firstly, it is very much scientific research. So it's molecular, biochemical, genetic information gathering. And secondly, it must be for the purpose of commercialising the material. So non-commercial research is not covered by the Act. Commercialisation is defined very broadly, means using the material in any way for gain. In this situation, I think it's quite clear to say that much of the research that goes on within the university is not covered. So basic taxonomic research, working with students, blue sky exploratory research will not be covered either under the definition of biodiscovery research nor under commercialisation. In the event that an activity is covered by the Act, there are a number of exemptions or situations where the Queensland law does not apply. It's important to keep these in mind going forward. Firstly, and broadly, the Act does not apply if the material is used to classify the material scientifically, so primarily taxonomic research. Secondly, the Act does not apply if someone's collected material and uses it to verify research results concerning the material. So if a researcher, whether it be for commercial or non-commercial purposes, publishes research results, say on a wild rice collected in Queensland, then a third party would be able to collect material to test and verify those research results. In doing so, they would not need to comply with the obligations under the Act. The third exemption that applies is in relation to educational institution, which is defined very broadly, but basically common sense understanding work quite well, or a person at an institution for educational or training activities not involving commercialisation of the material. So someone teaching a zoology course who wants to collect some sort of fish from a lake in Queensland state waters would not need to obtain a biodiscovery agreement to do so. In some ways, because the definition of biodiscovery research only applies to commercial activities, the provision is a bit redundant in the sense because it says it only applies to not involving commercialisation of the material. But anyway, it's good to clarify, and it's quite clear that people involved in teaching and training activities involving at educational institutions do not need to obtain a benefit sharing agreement to do so. The next exemption, which is the one that I want to speak about probably in more detail, which is newly introduced in the recent changes to the law, is in relation to plant material that are listed in Annex 1 of the Plant Treaty. This is the 2004 treaty I mentioned at the outset. The Act says that the Act does not apply if the material is from a plant listed in Annex 1 of the Plant Treaty to the extent that the material is taken or used for food or agricultural purpose and in a way that is consistent with the Plant Treaty. The Annex 1 exemption only applies to those 64 plants that are listed in the annex. The most important ones in Queensland would be citrus, rice and sorghum, which all grow in the wild in Queensland and are all mentioned under the annex. The annex does not include macadamia, so the exemption would not apply to someone collecting and working on some macadamia plants in southeast Queensland. Secondly, the use must be for research, breeding or training for food and agriculture. It cannot be for any other commercial activity. It also cannot be for something else, so biomedical research or cosmetics, things that it has to be for food and agriculture only. And thirdly, there's an obligation to fall under Annex 1 exemption that you apply the standard material transfer agreement, the SMTA of the plant treaty, that I'm sure many people working in this field are quite familiar with. So the upshot of this, if someone was to collect wild rice from state land in northern Queensland, and they were using it to undertake research that ultimately had the goal of, say, improving food or agriculture, so long as they use the standard material transfer agreement, when they transfer that material, they would not need to comply with the 2004 Biodiscovery Act going forward. It doesn't apply, however, for plants that are not listed in the treaty. So as I said, macadamias are one of the most the clearest examples, and also doesn't apply if someone's involved in, say, cosmetic research or biomedical related materials. Once it's become clear that someone is collecting and using native biological material from state land for the purposes of biodiscovery, in that situation, it's necessary for them to comply with the law. So in that situation, you would say a person in that scenario is in an obligation to comply with the obligations of the Biodiscovery Act. Research that we've undertaken in the past has shown there's been quite a bit of misunderstanding about the Act in many ways, and it's been one of the problems. It is relatively straightforward and simple, I think, and the state government has made it simpler going forward. So in order to obtain native biological material from state land or Queensland waters for biodiscovery, it's necessary for a person or an institution to do two things. Firstly, they must get a collection authority from the government before they go and collect. Secondly, they must enter into a benefit sharing agreement with the government and the person involved in the biodiscovery research. A collection authority, quite simply, sets out the conditions under which the material is to be collected, including when it's going to be collected, where, what, how much, and who will be in the collecting. It sets out the protocols for collecting, how they'll be stored, how they're distributed afterwards. Relatively straightforward. In addition, it's also necessary for someone collecting native biological materials from state land for the purposes of biodiscovery to enter into a benefit sharing agreement. A benefit sharing agreement is just a fancy word for a contract, really, between the person doing the collecting or the institution and the state government. It must do some things. Firstly, it must set out the benefits of the biodiscovery. It's provided by the biodiscovery entity to the state, and I'll talk about that in a moment. Secondly, when those are to be provided. And thirdly, if the benefits include payment of amounts of money to the state, the amounts or way of working out the amounts. The first and probably most important thing to take note about a benefit sharing agreement is that it includes both monetary and non-monetary benefits. Most of the discussions about biodiscovery and benefit sharing agreements focus and fixate, I'd say, on financial compensation, whereas in reality, most of the benefits derived are non-monetary. This might include a commitment to exchange all taxonomic information that's developed, to share the research results. In some situations, it may go further and people may provide training of relevant parties. Or sharing of equipment and things like that. But it is the most common method of dealing with things. It need not include, excuse me, need not include monetary benefits. It's also required for people into benefit sharing agreements to enter into, specify when the benefits are provided and then how they are going to be paid. An important condition that must be included in the benefit sharing agreement is a commitment, an obligation, a promise that you'll ensure that if you transfer the native plant material to a third party, that third party is subject to the same conditions that were imposed on the original holder of the collection authority. So this would mean that if I was to enter into a benefit sharing agreement with the state to collect macadamia from in and around Gympie, that I made a commitment that if I transferred that plant material to macadamia company in Hawaii, that I would ensure that when I did so, that I ensured that the American company comply with all the obligations and promises that I had agreed to going forward. So that really ends the sort of brief overview of the benefit sharing agreements in relation to traditional, in relation to native biological resources. I now want to turn to talk about traditional knowledge and the obligations under the Act. This is quite innovative aspect of the Act, but I just like to reiterate, and I'll do this again and again, the traditional knowledge obligation is not yet in force. The reason for this is the Act says quite clearly that the obligation will only come into force when the state government issues a code of practice. The relevant Queensland department dealing with the Act is in the process of developing a code of practice, and they have made some quite considerable progress, but there's a long way to go, and there's many issues to clarify. And it may be that the code of practice is issued effectively in stages, with the first stage being just quite general things and then following up going forward. But just like to reiterate that the Act aspects in relation to traditional is not yet in force, and it won't happen until the code of practice is finally introduced. But nonetheless, just to provide a way of background, I want to still alert you to the key features of the TK obligation under the law. The law provides that where a person takes and uses native biological material for biodiscovery, which we've already gone through, that's already clear. This part is not, regardless of whether or not the material is taken from state land or Queensland waters, and they access traditional knowledge when engaging in biodiscovery or preparing to engage in biodiscovery. There's a couple of things to note about this provision. Firstly, the use of traditional knowledge only applies in relation to when someone's taking and using native biological material for biodiscovery. So it's not a general right and protection over traditional knowledge, as people have been calling for. It's always tied to the use of native biological material. Secondly, unlike the biodiscovery provisions of the Act, it applies regardless of whether the material is taken from state land or Queensland waters. It's unclear at this stage whether or not it applies to materials collected from outside of Queensland or outside of Australia for that matter. What would happen if someone collected macadamia from a collection, macadamia germplasm from a collection in Hawaii and access traditional knowledge in dealing with it? Would they have to enter into, would they be under a traditional knowledge obligation? It's not yet clear, but it's something will be worked out hopefully in the code of practice. When a person is under a traditional knowledge obligation, they must take all reasonable and practical measures to ensure the person does not use the traditional knowledge for biodiscovery other than under an agreement with the custodian of the knowledge. So effectively, this will mean that in the event that someone is using traditional knowledge for biodiscovery, then they must have a prior agreement with the custodians of that knowledge. The Act says clearly that the obligation will be met if the person complies with the traditional knowledge code of practice, making it doubly important. Now, there are a number of questions that are yet to be clarified, and the government will do so hopefully fairly soon. At this stage, it's not clear what types of knowledge will be covered under the definition of traditional knowledge. Clearly, it doesn't include all knowledge. So the question is, what type of things are included? Is it knowledge about properties, functions of the material? I think clearly yes. Would it be knowledge of where plants grow? So if someone goes to Indigenous land and they ask an Indigenous person where particular plants grow, would that be protected? What about the best time to harvest plants to get certain properties from the fruit? What about the plant's place in the local or more general ecosystem? These are questions that will need to be clarified, hopefully in the code of practice going forward. Another question that needs to be resolved are what types of uses act as triggers for the traditional knowledge obligation. So does there need to be a direct correlation between traditional knowledge and biodiscovery research? So for example, if the Indigenous researcher told a non-Indigenous researcher about the benefits of a particular tree for use in drought, in times of drought. There's a direct correlation there. But what happens if there's an indirect correlation? What happens if in undertaking research on the drought resistance aspects of a particular plant that the university researcher stumbled on a different thing? Would that be a use? So this is the second bullet point. What happens if the information triggers or inspires further research? And if so, how far down the track? And then there's been some discussion, there doesn't need to be a non-obvious relationship, to borrow patent law language, between the information conveyed and the end product. These are very important issues that have yet to be clarified, but I think it's important that you be aware of them at this stage. Thirdly, questions arise about who the obligation is owed to. The Act talks about having to have an agreement with the custodians of the knowledge. One of the questions that the government is currently working with is how to identify the right people for the right country. So how does a researcher know that they're talking to the appropriate people who are the custodians of the knowledge? What happens, or what should happen, if traditional knowledge spans different communities? Should there be an obligation for the research to negotiate with all those different communities, or does that fall upon the knowledge custodians? And what happens if the traditional knowledge custodians are located outside of Queensland? These are important issues that need to be addressed going forward. One thing that is clear at this stage, and this is an important innovation in the Queensland Act, is that there's an exemption from the traditional knowledge obligation where the native biological material is from a plant that falls within Annex 1 of the Plant Treaty and is taken or used for food and agriculture purposes and is used in a way that is consistent with the Plant Treaty. So you must use the SMTA. So this is the exemption that I looked at before. So in this situation, if someone is working on wild rice and they collect it from state land, or in this case, even they don't protect it from state land because of the law, and they're inspired or they collect a plant on the basis of traditional knowledge, the Act does not require them to enter into a benefit sharing agreement with the traditional knowledge custodians. This is intended, along with the exemption for biodiscovery research, is to promote and encourage research for food and agriculture and food security purposes. There is something to be said, however, there are other reasons why people want to enter into benefit sharing agreements, and we'll talk about that towards the end. But this is, I think, of all the innovations in the Act, this is the one, I think this is the first time I come across this anywhere in the world. So just by way of conclusion, there are a number of things about the Act to bear in mind. The new Act is relatively streamlined. There's no longer a need to enter into a biodiscovery plan. All that a person involved in biodiscovery research in relation to native biological material collected from state land or waters, all they need to do is have those two things I mentioned before, and the most important of which is the benefit sharing agreement. There are, however, a number of issues that surround this going forward. Firstly, there's still a problem of forum shopping, and I think the problem here we have is not really a problem with Queensland law, although I think that there are some issues, particularly because it doesn't extend to non-state land. But the problem arises, we really have two types, to caricature this, two groups working in this space. Firstly, there's people who you could call biopirates. So those people who don't want to do the right thing. These people, say if they were working on a group of people from overseas, or maybe Australia, were working on macadamia, and they discovered that there was a new macadamia species growing between northern New South Wales and southeast Queensland. They would have the option of coming to Queensland and collecting the material, and it was on state land, and having to enter into a beneficiary agreement. What they could do, though, is they could go to a farmer in Queensland where the plant was growing, or go to New South Wales. and do so. However, someone working from a university who are adopting best practices, I think they should do, they would have to enter into an agreement. So one of the problems at the moment in Australia is that there's a piecemeal approach, it's fragmented. So we have laws in Queensland for state land, we have laws in Northern Territory for all land. There are versions of laws on Commonwealth land, but the rest of Australia is not covered. A second issue that has arisen that's important to bear in mind in this context is the question of Nagoya compliance. The Nagoya Protocol, as I mentioned earlier, came into force in 2014. Australia has signed but not yet implemented the law. Despite this, it is still very important for researchers and industry to think and know about. There are two reasons for this. The first one is that one of the things that the Nagoya does, it not only applies in the country in which it operates, it also applies when people are exporting to a Nagoya compliant country. So for example, if someone in New South Wales or working on non-state land in Queensland wanted to export plant material to France, which is Nagoya compliant, Queensland or New South Wales researchers in that situation would need to show that they were Nagoya compliant. Secondly, there are many non-state entities. The University of California, Nature Publishing, a number of other plant-based journals are making a condition of working with them that authors or would-be authors or researchers show that they have been Nagoya compliant. So somebody in Queensland who wanted to export a plant material to University of California would have to be able to show that they were Nagoya compliant in order for the University of California researchers to undertake research. The problem here is that the Nagoya Protocol itself is unclear in many key areas. There are three areas that I think to take note of just briefly. This is something we'll come back and possibly talk about in the future. Firstly, historical collections. It's unclear whether or not Nagoya applies to plants collected before it came into force or whether it only applies to plants coming to after. This is incredibly important for things like Nagoya, which is something that is operating outside the scope of the treaty. Secondly, digital sequence information. It's unclear whether Nagoya compliance extends to include people getting sequence data, sequence information about plants. And thirdly, there's also uncertainty about the overlap between the Nagoya Treaty and the Plant Treaty. And these are things that need to be addressed going forward. And the final thing to bear in mind is the question of what happens to traditional knowledge obligation if the code of practice is not approved. In 2004, the Queensland Government made a commitment to introduce within 3 years traditional knowledge obligations to follow up with its commitment and promise that they had made about recognition of Indigenous knowledge and biodiscovery practices. It took till 2020 for the government to follow through on that, but it's still not quite that, yeah. There may be a change of minister, there may be a change of government, and it's unclear at this stage what will happen if that happens. However, what is clear is that if there is a change in practice and the code of practice is not approved, then the traditional knowledge obligation will not arise. And this would be an unfortunate practice, but it is just the reality of going forward. Thank you for listening. Well, back to you, Robert.
Thanks, Brad. Thanks for that great overview. Time now, I think, to enter into some questions. One that someone's raised here is sugarcane excluded from the list?
Robert, would you like to?
Yeah, well, I think it depends whether sugarcane's native biological material. And I think it's fairly clear to me that Brad might have another view that sugarcane, hybrid sugarcane is not a native biological material, but there's some uncertainty about Sucarus spontaneum. It may in fact be native. to extreme areas in Queensland. So
I think
in
sugarcane.
most cases, you're okay.
I think sugarcane is certainly biological material. It's a question. I'm not sure whether it's covered by Annex 1 of the Plant Treaty.
I don't think it is.
So I think that then you would need to get benefit sharing agreement then.
Is this just about plants from Craig Hardner?
No, it includes all. I can go back to the slide actually. It goes back to includes.
I think it's anything that's non-human.
A substance sourced, yeah, any non-human living organism or virus. So it's certainly not just plants. So it's yeah. So, and it includes soil containing that. So we include micro-organisms, viruses, plants, animals, fish.
What does a typical benefit sharing agreement include?
Okay. It must, what it include with the names of the parties. I think if someone's interested, they could go to the Commonwealth Government Department of Environment, I think it's called now, and Heritage, has some examples on the website, but it must include the names of the parties. It includes these three things listed there. It must list the benefits to be provided by the biodiscovery entity to the state. And then it specifies information when the benefits provided and payments amount of money going forward. There have been very few of them issued to date. So I don't really think there's a standard one that's going forward. These are the minimum requirements. There may be other things that the party want to specify in there about how they share them afterwards, what they do going forward. I have seen some that are incredibly detailed and lengthy legal documents, but they don't need to be. This is the minimum material. The only other condition is it must be a commitment to ensure that if the material that's been collected and used is then transferred to third party, that you'll do so on the under the same conditions imposed on the original holder of the collection authority.
Here's a good one. How deep is the soil below private land?
Below private land?
Yes.
I've got no idea.
So I think it's getting at the question is it, can you go to any depth or does it become public at a certain point?
I don't know, actually. I don't know, I haven't got a clue. And it will be in the law, it'll be specified in the Act, in the relevant Act quite clearly, because it certainly deals with the airspace above your land changes, but I don't know.
Now we've got a comment from Nicole Thompson here that sugarcane's not native, only possibly Sucarrum spontaneum, as I mentioned, may be native, but most have been imported. So I guess this is the question, Brad, of what the word native means here.
Okay, I think we need to go back to one of the questions that has arisen in some contexts is when does something become, in a non-traditional knowledge sense, indigenous, and when things move around. So I think that it would be on a case-by-case analysis. I think is the only really way of dealing with that sort of thing. But it has to be something that's indigenous to Australia and sourced from certain. So if it's been imported from overseas and then goes wild, it probably not would be covered. But I don't know whether there's a point in time where something regarded as, because things do move around archaeologically, what sort of time scale. But I think if something's been imported, in living memory, then it would not be covered.
Yeah. Do we have any more questions? So while we're waiting, one of the questions I think that's central to this Brad, is the question of what constitutes being commercial. It seems a lot hangs in this on whether your research has got a commercial objective. Can you expand on that a bit more?
Yeah.
Or one of the situations that arises if you set out to maybe just to do some basic taxonomic research, but discover something that's got commercial value. Where do you stand?
Yeah, no, it's a good question. I think just to give you a sort of a back way in America, under patent law, there's an exemption for research, and it's a research exemption, and it's basically non-commercial. A professor of physics was working in a laboratory at one university. I think he had a falling out with people, so he left the university. He'd taken out a patent on a very large piece of equipment that he left behind, and the university continued. It was too big to take with him, and he tried to negotiate a license, and they couldn't work something out, and the university just continued to use it. He then sued, and the university tried to claim a research exemption for the purposes of research, but the American courts famously said that the students were being charged a fee because the university had a very prominent tech transfer office, which they very proud, like a UniQuest, that they proudly had on their website, that they couldn't claim to be a research institution in that sense, that they were engaged in commercial research. That has not been adopted in Australia, although there is a sense in which the more that people involved in money. The definition in the Act is using the material in any way for gain. So it is quite broad. I don't know if you've got an international fee-paying student, how the courts will respond. If it's, because now that all students have dollar signs attached to them, there is a chance in which it could, having material for students. The one saving grace here for students, however, would be that there's a special exemption for educational training activities, but it does say not involving commercialisation of the material. I think commercialisation of the material is something different than undertaking educational training on the material. So I think that would be the saving grace from someone.
To take the benefit question a bit further, I've heard it said that academics benefit in their career from publications, and so that if the research was to lead to a publication, it could result to the academic being promoted, and that would be a benefit. Do you think that that's captured? There's certainly been arguments around that from some Indigenous groups.
Certainly from Indigenous groups, yeah, that would certainly apply, I think. The benefit sharing agreement, as the law stands, only applies really to benefits that the researchers provide to the state. This is very much a law about providing benefits to the state for use of state resources. The traditional knowledge, things that would be about what benefits the researchers will provide to the traditional knowledge custodians. So it might be, in that case, co-authorship with those custodians of publications or whatever.
So do we have any other questions? We seem to have slowed in the questioning. Is there anything else you think we need to cover, Brad?
No, I think, probably just to sum up quite quickly, I think that the Queensland Act has simplified things quite a bit. So complying with the Queensland law is relatively straightforward. However, I think that for people working in this space, be they researchers or industry or bodies that fund those people, it's incredibly important that they step outside the Queensland law. It doesn't go far enough. I think that there is a number of reasons why people working in Australia need to be Nagoya compliant, for example. It's relatively easy to do if you get your ducks in line at the outset. but it's incredibly difficult to do, after the research has started. So I think that the key issues would be in relation to historical collections, how are they dealt with? So what would happen to, and how are we going to deal with historical collections of macadamia in New South Wales and Queensland, for example?
So Brad, I've found quite a few more questions, so maybe we can
I'll stop. Yep, go
on. Concerning commercialisation, research is done with no plan for commercialisation and then published, and then someone else in Australia or in the world takes a commercial opportunity. What happens there? Is there any obligation?
There's no obligation where there's no obligation where it's someone takes the published material and works from there. Just trying to find the. So there's no obligation where someone, so for example, a person was undertaking research on wild rice and to publish something about that and put it in the public domain. Third parties can then freely use that information to do what they want. The sort of law sees that as a sufficient juncture. However, if someone transfers the material to a third party,
yeah.
What's unclear is whether that would include sequence information from that material. That's the key issue that needs to be addressed.
What about beneficial organisms that could be used commercially for biological control?
What about them? Would they be? Sorry.
The question is, what about beneficial organisms that might be used for biological control commercially? Would they be covered?
Mm-hmm. Certainly.
Seems that they clearly would be.
Yep.
A question about, I think from Craig, I've lost it, about plant breeding. Plant breeding being, is plant breeding covered basically, or is it exempt?
No, certainly. If someone was
certainly covered, yeah, again, yep. Plant breeding, yeah, that would have thought so. And yeah. Do you regard Queensland as a first mover in regards to law in this area internationally?
In relation to the traditional knowledge Annex One obligation, yes. Queensland in 2004 was a world leader, but it slipped behind, I'd say. So we're catching up, but we've still got some way to go. If and when the traditional knowledge code of practice is introduced, we will possibly become a world leader then. But at this stage, we're just catching up to what most other countries have done.
One more question here from Craig Harner. Is there any way that, for example, a university could provide central guidance to researchers about understanding their obligations?
Yes, certainly they could fund. No, no, certainly institutions could provide clear guidance about how to go forward. But I think what really is important would be for universities to think about becoming Nagoya compliant. And this is something that, hopefully we can come back and address in the future. So institutions like the University of California have done, have said that they will make it a condition of working with all biological material that people be Nagoya compliant. If that is the case, it'd be quite clear that the institution would need to then follow up with education and training. It should be part of basic training for students, PhD students and staff. I suppose that this is an exercise in that that process that we're doing.
Is a specific question, are there any laws on using native plants from the Northern Territory in Queensland for research?
Yes, absolutely. There is very specific and broad-ranging laws in Northern Territory. I can't remember the years. The Northern Territory Biodiscovery laws apply to all land and waters in Northern Territory, and they have very extensive provisions in relation to traditional knowledge obligations. It's much more extensive than Queensland, so because Queensland only applies to materials collected from state land, in Northern Territory applies to all land anywhere.
So a couple of quick ones here. How do you access Annex 1?
I just Google it. It's Annex 1.
I think, yeah, you'll find it pretty easily on the internet.
Yeah.
Are there some resources that you'd recommend for essential reading for a better understanding of obligations?
I think Robert Henry wrote something recently on historical collections. If anyone has any wanted essential reading, they maybe just email me and I could direct them.
Maybe with particular areas of interest.
Yeah. Actually, no, under the ARC uniquely Training Centre for Uniquely Australian Foods, we have put up some resources there. We wrote a guide for the native plants industry a couple of years ago, and we've got fact sheets there. So maybe we could talk about making those more widely available across the university at some stage, but it's something they exist.
And from David Jefferson here, there's just a note that there were no changes to the definition of native biological resource or native biological material in the 2020 reform to the Act. In other words, anything that fell within the scope in the 2004 Act will still fall under the scope of the 2020 Act. I don't know whether that helps, but that certainly clarifies that that's an area where there hasn't been a change.
Yeah, no.
So whatever native biological material was, it still is.
Yeah, still will be.
Yeah, still will be. So it looks like that's come to the end of the questions I've seen. I think that's been a fairly useful range of questions. Hopefully people have got some answers to questions that they've had. So unless there's some urgent further question that's going to come up. Here's a good one. We obtain requests from overseas to obtain grafting wood from the macadamia germplasm. What obligations do we have prior to sending?
I'd want to know where it was collected from.
Yeah.
Where they're sending it to.
Yeah.
Tell them to email me, I think.
Yeah. Bruce Top, you'll have to email Brad. It requires further detail about this specific example.
Mm.
Are the Northern Territory traditional knowledge obligations workable?
Are they workable? They have worked. They're not traditional knowledge obligations in the sense that they are in Queensland, but there are lots. There have been some benefit sharing agreements that have been developed, and yes, they are workable.
Okay, well, given the time, I think we might draw it to a close. Thanks very much, Brad. It's been exceptional to get that overview and update of what's actually happened in the legislation for people to be able to interrogate you about particular issues. So thanks to you and thanks for everyone for attending. Hope to see you all at the next seminar. Thank you.
Thank you.